Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is September 2nd, 2021. This is our two-weekly community conference call where we answer your questions as best as we can, subject to all the caveats and disclaimers that you hear when you log into the community conference call. I did not mark any questions today as frequently asked questions. It looks like most of the questions I have answered before, so there's no need to mark them again as frequently asked questions. So I'll go through these questions, and I will not have time for new questions today. I've got to run to another meeting, but I will of course answer all the questions that have been posted and the follow-ups. So first question was, let me just make sure you guys can hear me, okay?
The conference is now in conversation mode.
Can you folks hear me all right? Am I audible? Hello?
Yes.
Thank you. Okay.
The conference is now in presentation mode.
So what are the most common reasons for denial of employment-based I-485 after 180 days following I-140 approval? Well, first of all, there is a misunderstanding here. You don't have to wait 180 days after the I-140 is approved. The law says I-140 is approved and 485 has been pending 180 days. Not the same thing. Think about it. If we file your I-140 485 today and 170 days later your I-140 gets approved, you actually have to wait only 10 more days because your 485 has been pending now for 180 days after 10 days. So don't confuse this, number one. Number two, there is very little the government can do to deny as long as the jobs are same or similar. I-140 is approved, 485 has been pending 180 days. I think it's quite safe to change jobs. We may have done definitely hundreds, if not thousands of these cases. And I have never had a denial, not once. So just make sure that your lawyers do the homework, they compare the job, and it should work out fine. We had one denial. This was when an employee left before the I-140 approval, but the I-140 was eventually approved and 485 had been pending 180 days. He went to interview, this was in Minnesota, government denied the case. We had them file a lawsuit and the government settled the lawsuit right away. They were trying to claim that you've got to stay with that employer for 180 days. I said, no, that's nonsense. That's never been the law. So in any case, it worked out well. I think it's a fairly safe process. Press *5 if you have a follow-up question on this. Press *5. Okay. *5 on your phones, guys, if you have a follow-up question. No? All right. So here is an F1 student who opted for day one CPT program. What will be the consequences? I'm a student on F1. Oh, so you've got to be a little quicker because I'm already moved on to the next question. Okay, area code 903, where are you calling from? Area code 903, I just unmuted you. Hello? Okay, I'm gonna... Raise your hand again. I had to put you down. Okay. Press *5 again. Texas. Press *5 again. Okay. Let's see if we can talk to each other now. Can you hear me? Texas?
Yes, hello, can you hear me?
Yes, go ahead, sir. Go ahead.
I can hear you, sir. Can you hear me?
Yes, I can hear you fine. Go ahead.
Yes, sir. So about this 180-day rule question. Yeah, so in my case, my ex-employer has filed for my green card application. They had a 140 approved. Now, in this case, I'm right now with my current employer on H1B. So I received my EAD card. Do I need to file the 485J straight away for my new employer since it's been pending for more than 180 days?
Let me understand the question. So you had a past employer through whom you filed your I-485. And now you want to port over to your current employer, correct?
Yes.
Your question is, should I file Supplement J right away or can I wait? Is that your question?
Correct.
Okay. Well, first of all, before you filed the 485, I hope you had a very detailed discussion with your lawyers about the pros and cons. But theoretically speaking, you can port over to an existing employer without any problem as long as you had the intention to join the past employer when you filed the 485 and they had the intention to give you the job. That laying aside that away, can you do it? Yes. Should you file a Supplement J right away? I like filing Supplement Js right away because they protect us at least procedurally. Okay. So the earlier you file, procedurally you are better protected. That's what I would recommend. Okay.
Yes, sir. So my ex-employer did file the 485J along with 485 because to show that it's a bona fide job offer, and I do have a job offer with them. It is just that my current employer wants to retain me and give me a better offer. So that is where my situation is. Now, I have two choices: to join the current employer as my original intention, because I received the EAD. But do I need to start the job on EAD or can I wait until I get green card? Or is it okay to switch over to the current employer?
You need at least a half hour discussing all possible implications. I can answer the short question that you posted, but I can't do a full discussion with you. Talk to your lawyers. But basically, if you were going to do a port over to a new employer, I would file the Supplement J sooner rather than later. Okay?
Okay.
Good luck to you, sir.
All right, thank you, sir.
You're welcome. Okay. For people who are joining in just now, let me remind you, I won't have time for new questions today. So we're just going to deal with the questions that have been posted and the follow-ups. So the next question from Raj was about CPT. So I have posted on my blog on immigration.com I think it's about the 10th or the 12th entry, a detailed entry about CPT, OPT, STEM OPT. Okay. And I've explained what CPT is. Now, the government may not like CPT and they might try to cause you problems when you do a conversion. What is the worst they can do to you? First of all, you should fight it like hell. Because as I have mentioned in my blog, this is a legal process. As long as it is a graduate degree, as long as it is an integral part of your job, of your course, as long as the employer enters into an agreement with the university, they can't stop you from doing an OPT. It's a part of a CPT. That's a part of the law. So they can try to hassle you, but the worst case scenario is they can make you go outside USA and get your green card from outside US. Means another 8 months, 10 months, a year, maybe extra. But they can't do anything more than that. And that's if you lose all your claims against the government, whether it's a litigation. So I think you should be okay if you got married. Would you be under scrutiny? Yeah, probably. But as long as the CPT has been validly authorized and you've been maintaining status by taking classes, you should be okay. *5 if you have a follow-up question. Press *5 on your phone if you have a follow-up question. Okay. A reminder for people who are just logging in, I will not have time for new questions today. I'm just going to be able to do the questions that are posted. So the question number 4 is, any negative consequences of not settling parents' medical emergency room bill while on employment-based adjustment of status? Excuse me. The answer is, I don't know. There are two components to this question. One component is a contract law component. I don't know what papers were signed. The bills are huge. You are unable to pay. You need to talk with the lawyer who does contract law locally in the city where you're located. As far as immigration law is concerned, unless you signed some kind of a paperwork, such as an affidavit of support for them, you have no obligation to support them. Okay. *5 if you have a follow-up question. *5. Next question is about EB2 to EB3 downgrading when you have concurrently filed I-140 and 485, and if the employer doesn't respond to the RFE, that can be a problem for you, because if the I-140 is not approved, the I-140 and the 485 both get thrown out. Question number 1, can we pull the original I-485 I-140 downgrade, apply fresh I-140 as a standalone application, get the I-140 approved, then apply a fresh? I don't know what you're talking about. Planning to apply for I-140. Well, I don't see any reason not to premium process the case. Somehow people have this idea that premium processing leads to more RFEs or deeper RFEs. I don't think so. I have not seen any evidence of that. And your questions require a lot of discussion. I'm not going to be able to cover them all. Pros and cons, etc. Each one of them is a 5-10 minute discussion. So what I would suggest is go talk to your lawyers. This is a fairly lengthy discussion. I can't do it on this community conference call. I don't see any point in pulling the original I-140 485. I disagree that premium processing somehow creates more problems for you. Why do we need to maintain the green card PWD wage once you get the green card EA2? If we take 2 months break, technically you are required to, the employer is required to maintain their ability to pay till the time your green card is approved. So if there are gaps in your payments, the employer will have to have that much bigger tax returns. Can we get paid less than the green card PWD with the new employer? Yeah, sure, within reason. If you go from, in the same area, from 140,000 to 70,000, that makes your case a little suspect. So if you go from 140 to 130 or even 120, maybe not so much. So generically, yeah, you can, but should you? Discussion with your lawyers. If we work for 2 employers, how to get the 485J? How to differentiate between primary and secondary? Well, first of all, because the green card is for a future job, you don't have to commit to 2 employers. You can always decide who is the employer with whom you want to work once your green card is approved, and they can be considered to be your primary employer. *5 if you have a follow-up question. *5. Area code 718. Area code 718, where are you calling from?
Yeah, I'm calling from Virginia.
Okay, sir.
So the follow-up question is, why the concurrent filings are not prioritized compared to straightforward EPC? And
okay, wait. I didn't understand that question. Can you repeat the first question again?
Yeah, sure. The downgraders are not getting processed quickly when compared to straightly applied EPC cases.
Okay, first of all, hang on
my priority date.
One second.
Yeah.
So, I think you misunderstand what a downgrade is. So, the way this works is, whenever we file a downgrade, any smart lawyer in this country would file the downgrade as a new petition. We don't file it as an amendment. Understand that. So what you are proposing should already have been done. When they file your downgrade, they should have checked on the Form I-140 new petition. Got it?
It's new petition only.
Yeah, so?
I work for the approval.
So?
Is there any difference between ED3 downgrade person and straight
No.
ED3 person?
No.
Difference between a concurrent filer or a straight person?
Okay, hang on. I'm going to give you one more minute to clarify this for you. The only difference is when you do a straight up filing, you have the original perm with you. If you have the original perm, you can ask for premium processing going in. That's the only difference. Otherwise, there is no difference between filing the case as a downgrade or filing it as a new application. That's what we do anyway. Okay?
But we do see the delays.
I don't care about that. What I know is this is the law. The law is this is what we do. I don't know what you see, what you don't see. Personally, as a lawyer, all I can tell you is there is no legal difference between these cases. Procedurally, we have not seen any difference. And I don't even know what other way there is to file a case. You will always file a case if you file a downgrade as a new I-140, attaching a copy of the perm application. So I don't see what the substantive difference between the two situations is. All right? Good luck.
Thank you.
You're welcome. Area code 612. Go ahead, please. Where are you calling from?
I'm calling from Chicago.
Yes, sir.
My name is Sandil.
Yes, sir.
And I was the one who wrote this question. And sorry, it was lengthy. The one last question I have is, if can I work for the primary employer on H1? And since I got my EAD, can I work with my primary employer?
Okay, hang on. You cannot split one employer H1 and one employer EAD. Once you start using your EAD, H1 is gone to sleep. You're using your EAD for both employers. Okay.
Okay. The moment I use this for EAD for second employer, for primary employer
also automatically EAD. Tell them to upgrade or change your I-9 to reflect your EAD. Okay.
Okay. Thank you, sir.
You're welcome. Oh, by the way, quick thing before you go. Remember that you can always do a concurrent H1. So employer A has an H1. Employer B can also file an H1 for a concurrent job for you. So you could do two H1 simultaneously. You just can't do H1 and EAD simultaneously. It's all EAD then. Okay.
Okay. Right now my 140 got approved in premium actually, and I got the EAD too.
Okay.
So
just use the EAD.
The case was different,
Yeah, you can. If you start using EAD, then you are on EAD for both employers. All right.
Okay, sir. Thank you.
Good luck.
Thank you.
You're welcome. Okay. Next question is, filing two I-485 applications. You filed two I-485s in October 2020. One based upon husband's EB1. Second, EB2 as primary based upon my employment. So one as a derivative, one as a primary. Because of the jobs. Okay. Recently, my husband and I got our green cards through his petition. Now my petition is still pending. Is it wise to send a letter to withdraw? No, just send a letter to withdraw, yeah. I always like to keep it clean. So just send a letter to withdraw. They should be doing it automatically. They're not going to give you two green cards, that's for sure. But send a letter to withdraw and that should take care of it. *5, if you have a follow-up question, *5. Okay, just a reminder for the people who are just joining us, I will not have time for new questions, only follow-up questions. I've got to go to a meeting. So Hannah wanted to know about employment opportunities in the US for a UK citizen. Hannah, you don't have any special provisions unless you want to invest money in the United States. You would have a probably E2 visa option, maybe a couple $100,000, $250,000. Could be lesser amount too, depends upon the project. So look into Treaty Investor Visa. Treaty Investor Visa. That's the only other exception for work visas that you would enjoy over other people. Otherwise, you have to go through the same process, H1B, find a job, have an employer apply for you, etc. Okay. *5 if you have a follow-up question on this. Press *5 on your phone. Okay. So you want to go from F1 OPT to J1 visa. I believe it can be done. I have never done one, but I don't see why not. The law doesn't allow you to go from a 212E requirement constrained J1 to another status within the United States, but it does allow you, as far as I know, to convert from any other status to J1. Can you transfer from F1 OPT to J1? As far as I know, yes. Why not? It takes a long time, obviously. Can I apply for change of status to J1 while residing in the US? Yes. Well, you shouldn't be out of status if you have filed the application timely. If you notice, in relation to F1 at least, the government has changed its policy and they don't consider you to be out of status just because they are taking so long to approve the cases. I believe they should take the same consideration for a J1. What is the current processing time for J1 visas in India? That's very difficult to tell because they are giving very few appointments. And you will also need a national interest exception. In your situation, I don't think you have much of a choice. I think you have to go for a change of status. *5 if you have a follow-up question. *5. Okay. Let's take the next question. Adjusting status from F1 visa after graduation. Okay. Our EB5 petition got approved in Jan. We would like to file for adjustment. Daughter was also on F1, came to USA in Jan. So we waited 90 days before we could file. USCIS has our 485 in travel and work authorization. Then the regional center authorizations lapsed. Question, how will I know if USCIS is still working on my travel work authorizations? I haven't been keeping track because we have currently no cases pending with regional centers. We have cases going through direct investment, but none right now through regional centers. I haven't been keeping track. Very sorry. If an individual has applied for adjustment of status while on F1, can they stay in US after graduating but no job offer? Yes, they can. Originally, we were hoping the work authorization would come, but now it seems bleak. Yes, sir. This part is easy. Because you have a 485 pending, you don't have to do any other activity. You are considered to be in authorized period of stay. *5 if you have a follow-up question. *5. Okay. So you have a pending 485 and you've tried everything including ombudsman. Okay, so if I get an RFE, I've submitted 485 AOS during December 2019, converted from EB2 to EB3, I-140 approved. I've raised multiple service requests and contacted ombudsman. I'm planning to apply for one more 485. I don't know if that's really necessary. You can. There's no harm. I mean, I don't know any law that says you cannot. As long as you use the same A number, they should be able to connect the two files and put a cover letter saying that this is the second 485 filing. There's nothing illegal about it. The government doesn't like us doing that, but what do I care whether they like it or not? Okay. I think you should try to contact a senator, a congressman. I definitely think that would help. Okay. *5 if you have a follow-up question. Okay, area code 718. 718, where are you calling from?
I'm from Virginia.
Yes,
So
sir.
what is the process of 485 usually have once the I-140 is approved?
Okay, let me understand
Like,
that
is there any
question.
time limit?
You said what is the process for 485 once the I-140 is approved?
Yeah. Once medical submitted document really qualified, and what they usually take steps to get this finished.
Well, that
criteria?
depends. That depends. Okay. Under Trump administration, they started interviewing all employment-based people. Before Trump, that was done rarely and randomly. It was done either if they had some doubt about the background or sometimes just for a random quality check. Okay. But Trump administration started doing interviews for all employment-based people. Now we are again getting some approvals without interviews. So if you get, there are two things that can happen. Either your file 485 will be sent to the local USCIS office to schedule an interview, which could easily add 1 to 3 years to your process, or you could directly receive a green card approval after the I-140 is approved. Okay, you might get an RFE for medicals. That is the only thing that I can think of. All right.
Is there any time limit?
No.
For this many number of months?
No time. They are not under any time limit now. Okay.
Thank you.
You're welcome. Good luck. Okay. So let's go on to so these are visa options for a part-time sponsored job as a psychometrist. So you were an Indian trained as a lawyer before you went into forensic psychology. You got a master's in forensic psychology, currently on 60-day grace period of OPT. You have a job offer from a professor. The position is part-time. You know that you can get a part-time H1B. If it is for a university, you would be exempt from the quota. As long as you are making enough money to support yourself. We have had H1s for part-time people, sometimes for as little as 15 hours each week. Sometimes we have to actually submit the detailed budget. I spend $300 on groceries per month, $200 on entertainment, $150 on gas money, this and that. So you actually may be called to submit your budget, monthly budget for expenditure. But H1B can be obtained for a part-time job also. I think H1 is the only option that I can see. I do not see any other option for you. Area code 984 has their hand up. 984, how can I help you? Where are you calling from?
Hi, I'm calling from Arlington, Virginia. I got a job. So I graduated in May, and I had an error in my EAD card.
Okay, hang on 1 second. Sir, I'm not doing any new questions. Hold on. And I actually announced that I will not be able to do new questions. But I'll try my best. Hold on. I'll do my best to answer your question, but not right now. So sit tight.
Sure.
Right now, we're just doing the post-it questions. Anybody has any follow-up question on this post-it question? Press *5. Okay. So the next question is about H1B cap exemption and I-140 processing. My perm was submitted June 2021. My maximum physical stay on H1B is expiring 30th October. Is there any cutoff date for leaving? 1 month before? No. You can leave right in the time that is given to you to leave. There's no cutoff. You don't have to leave X number of days early to save your H1 extension. Even if you have completed your H1, you can come back once the I-140 is approved, or labor cert has been going on for 1 year. So that means you are definitely coming back on 5th or 26th June 2021. But if the I-140 gets approved earlier, you can come earlier. What are the steps involved to come back to US? You have to get your H-1B processed, and that's pretty much it. I can't give you approximate timelines, too many variables there, but that's the way it works. *5 if you have a follow-up question on this. *5. Okay, let's see. Area code 551. 551, where are you calling from?
Yeah, I'm calling from New Jersey.
Yes, sir. Go ahead.
Yeah, so I have two follow-up questions to be precise. One is, can I come back in a different visa when my I-140 is approved?
You can come back in a different visa even before your I-140 is approved, but you will not be able to work unless you have a work visa.
I mean, sorry, I should be more precise.
Okay.
Can I come back in like L1B or L1A visa?
No, because you've exhausted 6 years of H1, you cannot get an L1. Okay. Go on to the next question.
Not new L1.
No, you cannot.
Okay. And the next question is, can I, once I come back, assuming everything goes fine, can I also run parallel another EB1 process along with the EB2 which is going on?
Well, you qualify for EB1A or EB1C. Is it as a international executive or because of extraordinary ability?
International executive.
You have to be outside USA, or at least you should have worked outside USA for 1 year for this company.
Oh,
okay.
Yeah.
And if you have,
if I complete one,
yeah, you can. You'll have to talk to your lawyers about that, because if there's a gap in between your statuses, I don't know how exactly that works. I haven't looked into that legal issue for a while. So can you do 6 months of L1 job outside USA, then come to USA for 3 years and do 6 more months? I doubt it. Have your lawyers double check it. So you'll have to stay outside USA for full 1 year, it looks like, and then you can come on L1 as well as file the EB1C. Okay?
Okay.
Good luck.
Thank you.
You're welcome. Okay. So let's go on to the next question. This is EB2 to EB3 downgrade, job change, 445 being filed concurrently. So you downgraded your EB2 to EB3, applied for 485. This was back in 2020. Then you changed your job at 3.5 month mark. Everything is pending more than 10 months. Am I at risk for AC-21 eligibility? Well, it's not the 3.5 month mark that's the problem. There are several other risks associated with this move. The most important one is if your I-140 is not approved, then you will not be able to port. You would just lose that entire green card. Will I be eligible for AC-21 if the old employer withdraws the I-140? No. No. See, AC-21 attaches only if the I-140 is approved and the 485 has been pending 180 days. If the I-140 is pulled before approval, you do not get the benefit of AC-21. Should I wait for downgrade I-140 approval? Yes, because you are right now not protected. If you file a supplement J now, they probably deny your entire case because they'll say, oh, you moved. Doesn't look like you had the intention to stay with this employer. So that can get tricky. *5 if you have a follow-up question. *5. Okay, let's see who this is. Just 1 second. Area code 718. 718, go ahead please.
So I'm from Virginia. Once 485 is approved, is there any time limit we got to be with current employer?
That's a long question. I've answered it about 17. I've answered that question about 17 times. Please look at our frequently asked questions. Okay? Good luck. You're welcome. Area code 860. Go ahead, please. 860. Go ahead. Oh, sorry. My mistake. Area code 860. Sorry, I just unmuted you. Go ahead.
Yeah, this is Suman from New Jersey.
Yes, sir.
And the last question was from me, and just one follow-up question on the second bullet point. So, more than 6 months has passed with the 485 and 140 street pending. But I read in their policy, like with the AC-21, if it is past 180, there is an approvable clause, meaning if the employee withdraws, but still it is approvable based on whatever.
Yeah.
It was filed,
So
still
that is true.
So,
That is true. That's not the question you asked me, though. The question you asked me is, what if they withdraw the I-140? If they withdraw the I-140, it doesn't matter if it was approvable when filed. Okay? So it has to be approved. They can't deny the case because you left the employer, but they can deny the case because the I-140 was withdrawn or the RFE was not responded to if there is an RFE. Okay.
Okay. So just to clarify on my second question, if as of today my employer withdraws, and if I file for, obviously they will issue a NOID for the 485, and if I submit the 485J, my understanding was they will look back the 140 and say, is it approvable? If yes, then probably they will approve my.
That's not the way I read the law. Not if it is revoked or withdrawn. I don't think they look at approval when filed if it is withdrawn. I could be wrong. I always learn new things as I go along in life, but I am pretty sure that's not the way it's gonna work. Okay. Actually, this issue came up in Bhavani Mantena's case in New Jersey in the Third Circuit. And that's a reason I remember it's one of our cases that we referred out. And this matter was discussed in great detail. So maybe you can look at that case. But I'm pretty sure if it is revoked or withdrawn, it doesn't matter that the case was approvable when filed. All right? Good luck. Okay, guys, I told you that I don't have enough time today to answer questions, but because some people have been holding for a long time, I'm not going to answer anybody who's been holding less than a half hour, because I've got some people who logged in 1 minute, 3 minutes, 13 minutes, 15 minutes, 17 minutes. Anybody who's been holding 30 minutes or more, I will answer their question. Raise your hand if you've been. Press *5. I've got 2 people, one holding 40 minutes, one 38 minutes. 2 questions I can answer. All right. 4 minutes. Sorry, I can't answer your question. Anybody less than 30 minutes. I've got 4 people who've been holding more than half an hour. I will answer your questions, guys. Let's begin with the longest time first. So you've been holding Texas 903, you've been holding for 40 minutes. Texas, you should be unmuted. Can you hear me? Texas?
Yes, sir.
Go ahead, please.
Yes, sir. So I have a question about, I did ask a follow-up earlier, but this is a question which popped up after you said something about EAD. So, sir, my ex-employer filed for my green card based on an approved I-140 EB2. The downgrade I-140 EB3 got approved, and I have the EAD.
Good.
I have a job offer, a better job offer with my current employer, and I have intention to join my ex-employer who filed my green card petition. Now, if my concern is to not give away my H1B, because I read that if something happens to 485, then I'm out of status and I have to leave the country.
Okay, I want to hang on. You should read our frequently asked questions. Okay, remember, if you start using your EAD, your H1B is not destroyed, it is merely rendered inert. Okay, so you can always revive that H1 by going outside USA and coming back in. So let's say you have 2 years remaining on your H1 when you started using your EAD, and something happened, 45 got denied. You can just go outside USA and come back on the same H1B if you have a job. The same H1B job, if you're still doing it, you can revive your H1B. It's not the end of the world at all. Okay.
So right now my H1B is expiring in February 2022. So let's say I start work on EAD and something happens.
Okay, listen, I'm gonna have to pass on this discussion. I'm just gonna give you the bottom line.
Sure.
Number one thing I told you, the H1B is not destroyed. It can be revived. Number two, you can always get an extension of the H1B and get a visa later. Okay? Good luck.
Okay, sir.
Yeah. So guys, like I said, I am in a hurry. So I will just answer. There are 3 more questions I need to answer. This one I'm taking 41-minute waiting from Pennsylvania. Okay. Pennsylvania, go ahead, please. I can hear you. Pennsylvania.
Good afternoon, Rajiv.
Good afternoon, sir.
So I have questions. First question is, I'm already working for a GC-sponsored employer in H1. After getting my green card, what is the minimum number of days I need to work for my GC-sponsored employer before I want to leave? Okay,
one second. I have answered this question at least 17 times in the last 7 years. Please read our frequently asked questions. I have a detailed discussion on this. Not to worry. Next question.
Okay, Rajiv. Second question is, for the same title I'm working right now, if a new H1B candidate is hired by my employer with the more salary than my current salary, and if my employer is not matching me the same salary that he is giving to the new employer, can I leave the green card sponsor employer after getting my green card, saying this reason?
Tough question to answer. That's a tough question to answer. I think you can. If you have a genuine reason to leave, and you can document that, first of all, I don't think it's going to be a big issue anyway. I think you can. So if you have a good enough reason, I think you could leave earlier. Okay? Third question.
All right. Thank you very much.
You're welcome. Good luck. Okay, I'm going to answer 2 more questions. People who've been waiting more than 30 minutes. And this one is from Massachusetts. It's a Google Meet call. So let's do the Google Meet call. Google Meet, go ahead, please.
Yeah, hi Rajiv. So I think this should be fairly simple.
No problem.
I just wanted to know if we apply for the EB5 green card, if my father applies for EB5 and can he put in my name and my brother's name? Both of us are about 21.
No. If you said your father, you're saying your uncle is applying for your father, is that what you said? Or is your father applying, like, for example, investment-based green card?
Yeah, investment-based.
They cannot, no. You are over 21. You cannot. No, sorry.
Okay.
All right.
Thank you.
Good luck. Okay, so the last question, I believe, this is the last one. Yeah, rest is less than, all others are less than half an hour. Okay, so 37 minutes. Let's go to what? This is New Jersey, 856. 856, go ahead, please. 856.
Hello, sir. Good afternoon.
Good afternoon, sir. Yes, I can hear you fine. Thank you.
Yeah. So my EB1C case was filed by my employer last year, and then I received an RFE, and then I received a denial as well about a year back. So recently I applied for the FOIA, and I have received the file from USCIS. So the managerial responsibility, so that is the reason for the RFE. But those kind of documents were were not exactly requested, the exact evidence was not requested by my employer from me to provide to the USCIS. So now my question is, already I received the denial. So are there any avenues or options open?
Oh, you could, if you are still qualified, you can always refile. That's not a problem. One denial doesn't foreclose another filing.
Yeah, refiling is one option, but again the employer has denied that, so I'm being asked.
Yeah, then there is no other option. You can't do an EB1C without the employer. No, sir.
Yeah. No, I was just wondering if I, the beneficiary, can file a federal case. Will the federal judge entertain that?
I don't think so. I don't think so, because your employer didn't respond. And if you are clubbed together with your employer, that means you did not respond. There's no lawsuit here.
Okay.
All right.
So whereby we can provide additional evidence to the USCIS through the case. That's not an option.
Not you personally. It has to be the employer. Okay.
Yeah. Okay.
Good luck.
Okay, thank you.
All right. So there was a student who had a question. If you are here, okay, I don't see you. Press *5. Okay. Well, guys, sorry, I can't answer any more questions. Like I said, people who had been waiting more than 30 minutes, I have answered their question. I will see you again in 2 weeks. I've got to run a little bit early today. Be well, everyone, and it's always a pleasure talking with you all. Thank you. Bye-bye.